Good morning, everyone, and welcome to our first Kites HR Breakfast Club of the year. My name is Lucy Scott. I am the marketing assistant here at Kites, and I will be your host for this morning's presentation. Excuse me, sorry. So for those of you who may be new to Kites, maybe you've never heard of us before, we are an award-winning commercial law firm based out of Manchester City Centre, and one of our key specialisms is providing expert guidance for employers and HR professionals. For those of you who have attended one of our HR breakfast clubs before, you already know what these are all about, and it's really great to welcome you all back. We hope everybody new or a past member of our HR breakfast clubs, we hope you all enjoy today and find it useful and engaging. So I will take you through the agenda shortly, but first I'm just going to introduce our two speakers. So today we've got two speakers from Kites. We've got Senior Associate Claire Hollins in our employment team, and then also we've got Associate Claire Treacy, also in our employment team, who will be your speakers for today. So Claire Hollins will be taking you through some recent case law updates and talking you through the government's latest living with COVID-19 policy. Then once Claire has finished that, she'll then pass over to the other Claire Treacy, who will be talking about protected conversations in the workplace. So let's just go on to the agenda. So this is the agenda for this morning. I'm just going to take you through like ways to connect with us and just like some brief housekeeping. Then I will pass over to Claire Hollins, who will be giving the case law update, and then she will also be going through the living with COVID-19 policy, like I said. And then Claire Treacy is doing the HR Hotspot, which is how to conduct a protected conversation workplace. So these are just the ways to connect with us. So we have our website, kites.com. So on there, you'll find insights from all of our different departments, employment included. And you can also join our mailing list on our website. So our mailing list is a great way to just keep up with all the content we put out. We send out a fortnightly bulletin with everything that we've posted from the past 2 weeks. News, articles, all that stuff is included in that newsletter. And then by joining our mailing list as well, you can also sign up to hear about all of our future events. And obviously, if you like the HR Breakfast Club, then you can sign up there to come to our next one. So that's our website. We've also got our social medias there. So we've got a Twitter, which is just @Kites Solicitors. Our LinkedIn is Kites Solicitors. And then our YouTube, if you just search Kites in your search bar on YouTube, you'll be able to see all of our YouTube videos that we've done. And on there, we also have a playlist of all of our previous HR breakfast clubs that we've done. So there's content on there that is definitely worth checking out. So yeah, I would encourage you to do that. So just some brief housekeeping. So if you do have a question, if we have time at the end, we will get to questions. There's a Q&A button at the bottom of your screen. So yeah, if you do have a question, please just use that to submit your question. And like I said, if we have time, we will get to your question. We will be sending a follow-up email after this as well. So in that follow-up email, we'll have all the details of the speakers, so the two Claires. There'll be a link to our feedback survey as well in that email, which we would be really appreciative if you could fill out. Dead quick, it'll only take you like 2 minutes, but it really helps us out. So please do that. And then there'll also be a link to sign up to our mailing list if you haven't already signed up to it. So like I said before, all the benefits of our mailing list, you'll get the insights, you'll get the event invites, and all of that good stuff. And then separately to that, we will be sending out the recording of this webinar. So you'll each get a recording of that, but then it will also go up on our YouTube channel afterwards as well. So that is it from me. I'm now just going to hand you over to Claire Hollins, who will be taking you through case law updates. So over to you, Claire.
Thanks, Lucy. So the theme for today's case law update is COVID. So essentially, I'm just going to talk to you for the next 20 minutes or so about COVID and COVID-related issues. And now, unusually as well today, all 5 cases that I'm going to talk about are first instance, so employment tribunal decisions. As employment lawyers, we are often interested in those judgments, the tribunals where we spend the majority of our time litigating for our clients. However, we wouldn't usually give those judgments too much importance because they're not binding on another tribunal, and the decisions stand largely for themselves. However, there are, I think, 3 reasons why I'm going to talk about first instance judgments today. The first is we don't currently have any appeal level judgments that specifically relate to the pandemic. So there aren't those cases to talk about at that level. Secondly, I think what the cases will do is give you a steer on how to address any similar issues that may arise in your workplace, especially as we start to progress through the living with COVID phase. And perhaps more importantly, number 3, they'll give you an indication of how tribunals are dealing with these cases day to day, and therefore what you could expect should you find yourselves facing a similar claim. Now, not only are all the cases about COVID, there's a common element in each case, which is the tribunal is being asked to consider the application of Section 100 of the Employment Rights Act. And I think it's fair to say that whilst historically there have been cases that have been brought under Section 100 since its creation back in 1996, it's seen a huge surge in popularity as a result of the pandemic. And essentially what Section 100 is, it's a special category of unfair dismissal. So one of the reasons I think that we've seen this increase in Section 100 cases is employees who bring their claims within Section 100 don't need to have completed the usual 2 years service to bring an unfair dismissal claim. And Section 100 is concerned with health and safety. So employees who are found to have been dismissed because of one of the reasons set out in Section 100 will have been unfairly dismissed. So otherwise known, and you might have heard the term automatic unfair dismissal. And the particular elements of Section 100 we're dealing with are employees who have been dismissed for bringing to their employer's attention by reasonable means circumstances connected with their work which they reasonably believed were harmful or potentially harmful to health and safety. Okay, so making complaints essentially about what's going on in the workplace. The second category are employees who leave their workplace or refuse to return to the workplace where they reasonably believe there to be serious or imminent danger. And then the third main category is employees who take appropriate steps to protect themselves or other persons from situations where they reasonably believe there to be serious or imminent danger. Okay, so that's the context, that's what we're talking about, that's Section 100. So let's have a look at how that's played out in real life, in real COVID-related claims. So the first 2 cases that I'm going to talk to you about concern employees who refuse to attend work. And as you will recall, a refusal to attend the place of work may be within those Section 100 automatic dismissal claim categories, depending on the particular circumstances. So Rogers and Leeds Laser was one of the first COVID-related employment cases to find itself in front of the employment tribunal. Mr. Rogers was employed as a laser operator within what was described as a large warehouse type premises. Now, the period of time we're talking about and the tribunal was looking at is back in March 2020. So back in March 2020, but before our first official lockdown that was announced on the 23rd of March, one of Mr. Rogers' colleagues developed COVID-type symptoms and was sent home from the workplace to isolate. Mr. Rogers had been working with him on that day, but at that point in time didn't have any symptoms in himself. And of course, this was a time before we had any COVID testing, really. So the day after the Prime Minister's announcement of the national lockdown, Leeds Laser confirmed that it would be staying open and that it would continue to require employees to attend their place of work. Communications were sent out, setting out the measures that they would put in place to permit this, and they were additional measures to those that they'd already got in place. So they were already implementing social distancing. They also carried out a risk assessment of the workplace with some professional support. Now, for the first 4 days following that lockdown, Mr. Rogers continued to attend work as normal. He then developed a cough and went home and subsequently texted his line manager to effectively say he wouldn't be returning to work until the lockdown had eased, and he referenced the fact that he had a vulnerable son and a 7-month-old baby. He was later dismissed for not returning to work and brought a claim relying on Section 100 and said the fact he was refusing to return was because he reasonably believed there was serious and imminent danger, and this was the step he was taking to protect himself and others from it. His claim was unsuccessful. In addition to there being issues around the consistency of his evidence, for example, despite saying he was concerned about COVID, the week after he refused to return to work, he took a friend to hospital. So the tribunal felt that that perhaps wasn't consistent with saying that he was fearful of COVID. But more importantly, the tribunal did not accept that his concerns were limited and specific to the workplace. He had a general concern about COVID generally in the wider community. And the tribunal didn't feel that the pandemic automatically meant there was generally serious and imminent danger in the workplace. The tribunal was also persuaded by the steps the employer had taken, and they could evidence, more importantly, that they'd taken to make the workplace safe, and particularly the size of the premises, so the ease at which social distancing was possible. And they sort of said Mr. Rogers' concerns were effectively too general. He couldn't give specific examples of what the particular concerns about his place of work were. Okay, so that's Roger. He was unsuccessful, but the case is being appealed. So that could be then one of the first employment appeal cases we have on COVID, to watch this space. Now, Moore and Ecoscape is similar in many ways. Ecoscape is a special environmentally friendly construction materials business. It's a small business employing around 20 staff, majority of which worked in a warehouse area. Mrs. Moore was a member of the administrative and sales team, and she worked in an open plan office, typically with 2 or 3 other colleagues. When lockdown was announced back in March 2020, Ecoscape closed its operation and furloughed its employees, including Mrs. Moore. She was asked, along with another member of staff, to go into the office the day after lockdown was announced on the 24th of March, tie up some loose ends, but she refused to do so, so she was concerned about COVID, and no issue was taken with this at that time. Now, once UK State realised that all their competitors had remained open and they were relying on the construction exemptions in place at that time, the decision was made to reopen the business. And all the employees, including Mrs. Moore, were taken off furlough. It's fair to say Mrs. Moore was quite unhappy with the decision to reopen the business, and she sent messages to her manager to the effect that she believed the decision to be selfish and irresponsible, and she refused to return to work. So what EcoSpace did is they talked to her about the measures they'd put in place, which included risk assessments, staggered start and finish times. They weren't taking cash payments, there was social distancing, etc. But she still refused to return. So initially they agreed that she'd take a period of annual leave that she still had, and then she went on to agreed unpaid leave. And as business picked up, they continued to talk to her about returning to work. They ran through the steps that had been taken to protect the employees. But Mrs. Moore effectively said, I'm not doing that. I don't trust that my colleagues will comply. And whilst I am able to work, the only way in which I'll consider doing that is from home. And I'm not prepared to change my mind on that whilst there are high levels of cases in our locality. Again, more discussions took place. They tried to explore with her any further steps they could take. They talked to her about why they felt home working was not appropriate. And she continued to refuse to return. She wasn't being paid at this time. She was told that her absence was being recorded as unauthorised, and she was threatened with disciplinary action. She raised a grievance, and in response to that, what the employer did was to look again at the situation. They talked to her again about what steps they had taken and were willing to take to try and sort of, I guess, encourage her to return to work. Ultimately, her grievance was not upheld, and eventually she resigned and claimed she'd been dismissed for refusing to return to work for health and safety reasons under Section 100. Similarly to Mr. Rogers, her claim failed. And the reason for this was the tribunal did not accept that her belief that the workplace was unsafe was objectionably reasonable, given the efforts that had been made to secure the workplace and the discussions that had taken place. The tribunal felt that Mrs. Moore was fixated with the guidance that had been issued by the government for people to work from home where possible, and she'd not really engaged with the fact that it wasn't feasible for her role to be undertaken remotely. So I think what we can take away from these two cases is that where we've got employers who are acting reasonably by listening to concerns, taking steps to address them, they've succeeded in being able to defend their claims. And I think these are sort of classic cases of the tribunal finding in favour of the party that appears to have conducted itself most reasonably. And of course, in these cases, both of the employers were lucky to have that evidential trail showing the discussions that had taken place and what steps they had taken to make the workplace secure. So moving on to refusals to return to the office, and predominantly this is following a period of home working. The first case, Montemaro and Landsafe, concerned an IT professional. His employer, Landsafe, provided outsourced IT services and staff to other businesses. Some of his work meant that he needed to be on site, but the vast majority could be undertaken remotely. In early March 2020, Mr. Montemaro flew to Italy to attend his sister's wedding, which, with the benefit of hindsight, perhaps wasn't the best move. But prior to this, he'd emailed his line manager to request holidays. He hadn't followed the correct process, but that was because the company hadn't told him what the correct process was for booking holidays. and he hadn't received a proper induction when he joined the company the previous month, and he didn't have access to the employee handbook either. The day before he was due to return from Italy, Italy went into lockdown, although travel for work purposes still remained permissible at that point in time. And Mr. Montanaro knew that if he did return, he'd have to isolate for 14 days, but he wasn't sure whether he was permitted to travel or what documents he would need to be able to do so. Now, he relayed his concerns to his manager and said that he was unable to return to work, and he was told to wait for a response. As he didn't have proof of travel for work, he didn't attempt to catch his flight home. And rather than providing the instructions that they said they would, Mr. Montanaro's manager actually wrote to him to advise that he was being dismissed for taking unauthorised leave. And that letter, which contained a number of factual errors anyway, wasn't received by Mr. Montanaro because the company said they sent it to his home address. Of course, he wasn't there. And ManSafe had backdated the date of his dismissal to 3 days prior to him leaving the UK as well. Because he hadn't received that notice of dismissal, Mr. Montanaro continued to work remotely from Italy. He wasn't challenged about this, and he just got on with his job. Then on the 1st of April, he received an email to his personal email account from the HR manager, which referenced his dismissal and attached his P45. So that was his first notice of his dismissal. So in response to this, Mr. Montanaro brought a claim for unfair dismissal, again relying on section 100 given his short length of service. And the tribunal agreed with him that the pandemic presented circumstances of danger and that he'd taken reasonable steps to protect himself and others while remaining in Italy and working remotely, which he was able to do effectively. Now, clearly, in that case, the fact that the employer had fudged things didn't help them. Now, Quelch was a case concerned with an employee in the financial services sector. He was a compliance analyst. He lived in a one-bedroom flat with his girlfriend who was clinically vulnerable. Before the lockdown was implemented, it was agreed that he would work from home. And then when lockdown started, courtiers determined that their employees were critical workers and they remained open, although a number of employees did work from home, including Mr. Quelch. Eventually, they dictated that a return to work was to happen, and they decided to do that in phases, with Mr. Quelch being in the last phase. Now, when it came to his sort of turn to return to work, he refused, and he cited guidance still in place at that time, saying that employees should work from home where possible, and he also highlighted the risks for his vulnerable girlfriend. He was very specific in his concerns. He said, well, I'm going to be working with others who've got children at school, so this is widening my sort of potential contacts and the risk of transmission. He also raised concerns about whether the workplace was COVID secure, in part because the company had shared a photograph of colleagues celebrating who weren't social distancing. He also pointed to the fact that he was effectively working from home, supported by his manager. When he refused to return, his IT access was cut off and he was disciplined. He raised a grievance about his treatment, making it clear he was able and willing to work from home. They refused to hold a disciplinary hearing remotely, and he was dismissed. He appealed the decision, and by the time that appeal hearing took place, the guidance had changed, and he was comfortable coming into the workplace for that. His appeal was rejected, and he brought a claim under section 100. And the tribunal found he had been unfairly dismissed. The tribunal found that his beliefs were reasonable. He'd communicated clearly what his specific concerns were, and that he considered the government guidance should be complied with. And he was consistent in his position and entirely reasonable. The tribunal also took note of the fact that he'd been able to effectively work from home. So again, what these two cases show is that the party who takes the more reasonable approach is likely to succeed. In both these cases, different to the first two, the claimants were able to point to specific concerns that have been raised and why these were not being adequately addressed by their employer. And with Mr. Quelch, it was also highly relevant that he lived with someone who was clinically vulnerable, which made his concerns all the more reasonable. And I think what this shows is it's a good lesson in employers listening to what their employees are saying and not taking that blanket approach. So the final case about Gibson and Lothian Leisure is all about employees' rights to voice their genuine concerns. Mr. Gibson was a chef at a hotel. Similarly to Mr. Quelch, he lived with somebody, his father in this case, who was clinically vulnerable. He had a number of medical conditions. Following lockdown, he was furloughed. There were some issues with his furlough pay not being paid correctly, pension contributions not being made as well. Then in April, in anticipation of hospitality being allowed to reopen, Mr. Gibson was asked to come in and help out. He raised some concerns about doing so because of his father. He said staff aren't being provided with PPE, no precautions are being taken to ensure that the workplace is COVID secure. The response to him was wholly negative, and he was effectively told to shut up and get on with it. And he said from this point, he was perceived to be a nuisance, despite there having been a previous good relationship. And then without any prior warning, Mr. Gibson was dismissed by text message from one of the directors. He was told that once they reopened, they were intending to go with a smaller team, so they didn't need him. He didn't get any notice pay, no pay in lieu, no holiday pay. So he brought claims for unfair dismissal and lawful deduction from wages and for his unpaid notice. And the tribunal accepted that he had genuine and reasonable concerns for his father, and therefore, in raising those concerns, that brought him squarely within Section 100. And the tribunal found that there'd been no concerns on the part of the employer with Mr. Gibson until he'd raised those issues, and therefore he'd either been dismissed for raising them or he'd been selected for redundancy for doing so. And clearly, the employer's complete failure to either engage with Mr. Gibson about his concerns or to follow any process when dismissing him were of concern to the tribunal. So again, what we can see is that where specific and reasonable concerns raised in a consistent and measured way, and an employer fails to properly engage with the employee, the tribunal is more likely to find in favour of the employee. And conversely, those employers who engage properly with their employees, took steps to alleviate the concerns, were more likely to successfully defend their claims. And I think it's fair to say blanket approaches are unlikely to curry any favour in the tribunal. So now we've looked at the cases, let's have a quick look at the government's living with COVID-19 policy and where we are now. So we've had the announcement of the end of COVID restrictions for England. Of course, you need to remember if you have employees in jurisdictions of the devolved governments, the provisions are likely to be slightly different there. And I think, you know, as we've got on the slide, the main change is the end of mandatory self-isolation if you test positive. Guidance still remains for employees to isolate if they do test positive, but it's not mandatory, and that guidance is due to be reviewed in April. Okay, so all of these changes that we can see on the slide are inevitably going to have an impact on the workplace and give rise to some issues for you as employers. So what sorts of issues are we expecting, and what do we think you need to consider? Well, I think the main thing is that your health and safety obligations are not changing, even though we have this living with COVID situation now. As an employer, you still have the common law duties to provide a safe place of work, a safe system of work, and that's in addition to all your statutory duties under the Health and Safety at Work legislation. So that means you still need to be undertaking risk assessments, and you probably should be updating these given the change in the isolation rules, and particularly if you are requiring or starting to require your employees to return to the workplace. Linked with that, you probably need to start thinking about updating your policies. You need to think about what's our policy going to be for employees who test positive now that they don't have to isolate. And of course, you need to bear in mind that the guidance is still that you shouldn't attend the workplace if you're positive, but that is only guidance. And employees no longer have to tell you if they are positive. So as the employer, you need to think about, well, what do we require our employees to tell us? Are we going to require them to stay at home? Are we going to require them to work from home? Or are we going to be content to allow employees who we know have tested positive to come into the workplace? And I think this week we've seen some fairly public backlash against companies who have said that that is their intention, or have been accused by their employees of saying that that is what's going to happen. So it isn't just an employment health and safety issue. There are PR issues there as well. So if you are requiring employees to stay away who've tested positive, you need to be thinking about, well, what are we going to pay them if they can't work from home? And you're going to have to clearly communicate your policy on that, and bear in mind that employees who won't be paid for isolating may then still choose to attend work, particularly if they're asymptomatic or able to largely hide their symptoms. And what we're seeing is some employers are starting to think of this as a wider issue than COVID, and are putting in place more general infection policies to make it clear to employees what the expectations are when they can and can't attend work, and what they'll be paid. And if this is something that you're thinking about, please do get in touch with us and we can help you to formulate your policy on it. As part of your health and safety obligations and your risk assessments, you're going to need to continue to consider what COVID safe steps should remain in place. For example, are you going to have a face mask policy or not? And again, this all needs to be clearly communicated to employees. I think it's fair to say with the dropping of restrictions, you may see an increase in reluctant returners or employees who previously would attend work now voicing concerns because they may be working with colleagues who are COVID positive. And as you will hopefully have gleaned from my case law update, it's going to be important to engage fully with those employees and to address their concerns and be able to evidence the steps you've taken, the discussions that have taken place. Linked to that, you may see an increase in flexible working requests, more employees asking to work from home for all or part of their working week. And where home working has been operating successfully during the pandemic, you may now find it hard to refuse those applications. And bear in mind, if you do refuse a flexible working application, you may not simply be facing a claim for breach of the right to request flexible working rules, but more likely a discrimination or a Section 100 type claim. And of course, where you have vulnerable employees raising concerns or refusing to return, you're going to have to take extra care, and I would suggest advice on that. The dropping of the restrictions, it doesn't absolve you of your obligations to make reasonable adjustments for your vulnerable and disabled employees, and that might include additional safety measures, working from home or hybrid working. So I think, in short, until the pandemic gets the message that it's over and actually disappears, which the reported increase in infections and hospitalisations this week would suggest isn't likely in the immediate future, you are going to have to continue to take appropriate steps to deal with COVID in your workplace, or you are going to unfortunately run the risk of successful claims being brought against you. Okay, that's everything I wanted to say about COVID. So I'm going to hand over to Claire now to talk about protected conversations.
Thank you, Claire. Morning, everybody. So yeah, as Claire says, I'm going to do the HR Hotspot, which is how to conduct a protected conversation. So as if we just move on to the next slide, Lucy, as it says on the slide, an off-the-record conversation with an employee regarding the termination of their employment with a view to it being terminated on terms agreed between the employer and employee. So that is the premise of a protected conversation. And then if you've managed to agree something with the employee, it will normally be recorded in a settlement agreement. The conversation itself won't necessarily just last for one conversation, as the name suggests. In order to get an agreement, quite often the conversation can go on for a few days or even weeks in certain situations before an employee and employer have managed to agree whatever the terms are going to be. So many of you are probably familiar with the concept of a without prejudice conversation, and that also allows an off-the-record conversation, but it is different to the concept of a protected conversation. The reason being that a without prejudice conversation only applies where there is already an existing dispute. So by existing dispute, I mean where there's already a tribunal claim, or where an employee has made it very clear to you that that's what they're intending to do. They're intending to lodge a tribunal claim against you as a business. If that happens, then quite often there will be without prejudice discussions to try and settle that. But that's obviously quite narrow in scope. It doesn't give the employer, doesn't give employers a lot of flexibility to have off-the-record conversations, because there needs to be that genuine attempt to settle an existing dispute. So that presented a problem for employers, which led to the introduction of Section 111A of the Employment Rights Act, which introduced the concept of a protected conversation in 2013. And that basically gave employers more flexibility, because it said you could have an off-the-record conversation with employees, even where there isn't already an existing dispute. And the idea is that if you have a protected conversation and you do it properly, then you can't refer to it in tribunal proceedings if the settlement discussions fail and the employee goes on to lodge a claim. So the employee, for example, couldn't say, the decision to dismiss me was predetermined, as evidenced by the fact that you tried to have an off-the-record conversation with me beforehand. It is really important to note, though, and always remember, if you're thinking of having a protected conversation, that they do only apply to unfair dismissal claims. So as it says, that includes constructive dismissal claims, but not automatic unfair dismissal claims. Whereas without prejudice discussions apply to all types of claims. So, for example, discrimination claims or whistleblowing claims as well. So whilst very useful, they are narrow in scope in that they only apply to certain types of unfair dismissal claims. So before you even have a protected conversation, it is really important that you consider and take advice on what the employee's potential claims could be if a settlement isn't actually reached between the parties. So if the protected conversation fails, just so you're aware of what the risk could be if the employee does later pursue a claim. So if we just move on to when might the need for a protected conversation arise, usually it's when an employer or an employee feel that the employment relationship is no longer working, and therefore they want a clean break and decide that's the best way forward. It can be started by the employee or the employer, but more often than not, we will find it's the employer that starts a protected conversation, probably just because a lot of employees won't necessarily know that's a possibility. And I think these examples on the slide are the most common situations when an employer is likely to start a protected conversation. So the first one being an alternative to carry out a disciplinary or capability process. So if you've got an employee that has 2 years service or more with the business, but you've got performance concerns about how they're getting on in the workplace, but they don't have any live disciplinary sanctions on their file already, it's going to be quite difficult to get rid of them fairly quickly, or to exit them from the business fairly quickly, without first following a formal and quite thorough capability process. Otherwise, you're going to be putting the business at risk of a successful unfair dismissal claim. So in that situation, it might be helpful for the employer to approach the employee, explain what the performance issues are, where they're going wrong, and what you expect of them, and explain that your plan is to start a formal capability process with them, and you can explain what that looks like, and that ultimately that could result in their dismissal, but obviously subject to the process. and therefore, as an alternative, you would like to have an off-the-record conversation with them to see if you can agree mutually acceptable terms for their exit. And then if the employee is willing to enter into that conversation with you, that may be a lot quicker way to exit them from the business if that's what you want. And the same applies really in a disciplinary situation. So again, employees with 2 years service or more have the protection against unfair dismissal. And so you're going to have to follow a full disciplinary process to be able to remove them from the business. And if they've done something which you're not happy with, but potentially doesn't warrant a dismissal at that stage, then a protected conversation could be beneficial for you as a business. Employment relationship no longer working yet. So perhaps there have been issues with an employee and they've indicated that they are unhappy and the company suspects that the employee may want to leave. Could be worth having a protected conversation then. Or similarly, a clash of personalities. So quite often you find an employee doesn't get on with their manager or vice versa. That is causing problems in terms of productivity within the team and attitudes at work, that kind of thing, but potentially it doesn't warrant a disciplinary or performance issue, then the best way to try and resolve that is likely going to be via a protected conversation. And then finally, on this slide, organisational changes. So if, for example, you are or have restructured the team, and potentially that doesn't quite mean that a particular team member fits anymore, but that doesn't amount to a redundancy situation, then it might be beneficial to have the conversation. Or even if there is a redundancy situation, but as a business you want to ensure that a particular employee stays and some employees go, or you just don't want to carry out a redundancy consultation process, then again, that might be a situation where you would want to consider a protected conversation. If we just look next then at improper behaviour, Lucy, if you don't mind changing the slide, please. Thank you. So protection is lost if there is any improper behaviour. So if you're going to have a protected conversation with an employee, you need to make sure that it's done properly. If it's not done properly, i.e. there's been considered to be improper behaviour, then there is a chance that an employee may bring a claim if the conversation isn't successful, and then they seek to rely on the conversation as evidence at a tribunal that you wanted to terminate them from the business. But what we see more often than not is that actually you get employees using it as leverage to try and increase the settlement proposal that you offered them. So you'll know that when there's a settlement, you would usually record it, as I said, in a settlement agreement. So therefore the employee has to go and get independent legal advice on the terms of that settlement agreement. And you can imagine the situation where obviously they are being asked to explain the background as to why they've been provided with a settlement agreement. And if during that conversation the employee explains that there was the employer acted aggressively or whatever it is that constitutes improper behaviour, then they're more than likely going to be advised to ask you for more money under the terms of the settlement agreement. Otherwise, they can say, you know, I'm not happy to accept the settlement you've offered me now, and I will take it to a tribunal if you don't. So you're going to imagine that situation happening. So you want to be in a really strong position to be able to say we did everything properly. The law requires or allows us, I should say, to have protected off the record conversations with our employees. It is worth just saying though that even if an employee is able to refer to a protected conversation in the tribunal, it won't necessarily mean that that unfair dismissal claim is going to be successful. It's just that they will be able to refer to it as evidence, and it could persuade a judge. What constitutes improper behaviour though really does vary on a case-by-case basis and will depend on the individual involved. So for example, if we've got a particularly vulnerable employee, that's what constitutes improper behaviour towards them could be quite different to what constitutes improper behaviour towards somebody else. ACAS though does give a list, so there's a code, an ACAS code on how to deal with settlement agreements and protected conversations, And that does give a guidance basically as to what could constitute improper behaviour. So it's those things that I've put on the slide here: harassment, bullying and intimidation. And that includes the use of offensive words or aggressive behaviour. So if during the conversation you're particularly intimidating or aggressive towards that employee and they can evidence that, that could constitute improper behaviour. All forms of victimisation. So if the employee has raised a grievance, which includes discrimination issues, and you as an employer then have a protected conversation with them to try and remove them from the business, that could well amount to victimisation and improper behaviour. And then discrimination. So if the conversation itself is discriminatory, so if, for example, you have been told by an employee, for argument's sake, that they are pregnant, and you then have a protected conversation to try and remove them from the business, because of that, the conversation itself could be held to be discriminatory. And then undue pressure, which I think is the most common example as to where employers will generally fall when having a protected conversation. So that's if you put undue pressure on the employee to accept the settlement when you're having the conversation with them. Again, undue pressure is one of those ones where it is going to vary from case to case. But again, ACAS does give examples and says, for example, not giving a reasonable amount of time for the employee to consider the settlement. So ACAS says that you should give at least 10 calendar days for an employee to consider the terms of a settlement agreement. So that's so that they can review it and then go and get the independent legal advice on it. You might find though that, you are able to agree a shorter time frame with an employee, and that's absolutely fine. If they say, I don't need that amount of time, then that won't be a problem. Equally, you might find it's the other way, and you've got an employee that's asking for a longer amount of time, and you're going to need to consider on a case-by-case basis whether it's appropriate to give them longer. If you do, I would say you definitely want to agree whatever the time frame is going to be. It shouldn't be an open-ended type thing. And another example given of undue pressure by ACAS is that if an employee is told if they don't accept the settlement, they will be dismissed. So it's fine to say that, if they don't accept it, then you are planning on starting the formal disciplinary process, which may result in your dismissal. Just don't go suggesting that any kind of decision has been predetermined about their future with the business. And then also telling the employee that the financial offer will reduce the longer that they take to consider. Obviously, that's going to be undue pressure, as well as giving them any kind of ultimatums. So before you go in to have a protected conversation, you need to definitely make sure you're clear on what it is that you're intending to say to the employee during that conversation. So on that, we'll have a look on the next slide about or how to conduct a protected conversation. So as it says, prior notice of the protected conversation. So you're going to want to consider whether you want to give prior notice of the protected conversation. The ACAS guidance does suggest that it would be good practice to give an employee prior notice, basically, so they can prep themselves for it. I would say that it's definitely not necessary to do this in all situations, and sometimes it's beneficial not to give an employee notice because it keeps it more informal with them, and also it just keeps it more informal so that the conversation can potentially be more open. And if you've got an employee that's working in the business and you give them, say, 3 days notice of the protected conversation, then it's going to be quite difficult for them to concentrate on their actual work. It's going to make for quite an awkward environment, and also they're probably going to start talking to their colleagues about it. Whereas on the flip side, you might have some employees that are particularly anxious or nervous people, and therefore you think it will be a more beneficial and productive conversation if they do have some notice and warning of it. So just consider in the situation that whoever it is that you're dealing with, what the correct method is there. explain the circumstances that have led to you having the protected conversation. So yes, do this in a calm and neutral way. So I would start off a conversation by explaining why you're having that protected conversation in the first place. Is it because there's disciplinary issues or capability issues? The reason being that you're just really going to want the employee to understand why you feel it's necessary to have the conversation for them to exit the business. And hopefully that will help to secure their agreement to settlement terms. Yeah, ask the employee if they're willing to participate in the protected conversation. So that goes also alongside making sure they understand what a protected conversation is. And then you can literally ask them the question once you've explained the background as to why you're having it, what it is, and say to them, are you willing to participate in this protected conversation? Obviously, you can't force an employee to do that. But if you've got their agreement, make sure you note that down. It will then be harder for an employee to argue that there's been improper behaviour if you've got their agreement to having it. Remind the employee of confidentiality and that the conversation is intended to be off the record. So yeah, you don't want them going back to talking to their colleagues about the protected conversation. And yeah, you want them to understand what off the record actually means. So once you've done all that, obviously the most important thing being explaining what your settlement terms are. So be clear on whether you, when you want their employment to terminate, whether you want them to work their notice or if they're going to be paid in lieu of it, what financial offer, importantly, you're going to make to them, and whether there'll be a reference included in that, and decide if you're going to be providing them with a settlement agreement there and then, or are you going to give them some time just to consider what verbally you've said to them, and then follow up with a settlement agreement once you've got the terms agreed in principle. So again, that's a bit of a case-by-case basis as to what you think will be most beneficial to that employee, or the thing that's going to persuade them into accepting your settlement the most. And confirm what the alternative to the settlement may be. So yeah, just to repeat again, really making sure that employees understand that whilst they're under no pressure whatsoever to accept a settlement, if they don't, then you will, for example, be starting the formal capability process, but their decision regarding the settlement will have no bearing whatsoever on the capability process itself. And then if we just look at final tips really on the next slide for carrying out a protected conversation, just the most important things I think to take away from this presentation: make sure you get the employee's agreement before any talks and take a note of their agreement. Don't give the impression that dismissal is inevitable, only that it's an option following a full process. Provide the employee with a reasonable amount of time to consider. As I said, ACAS says 10 calendar days from the date you provide them with the settlement agreement. But if you're not providing them with a settlement agreement, you're just verbally explaining the settlement terms to them, then you can be more flexible. But you're going to need to decide what that right time frame is going to be in the particular circumstances. Having in-person discussions. So yeah, I just put that because obviously a lot of things we do now are like this, virtual, and you might find though that in-person discussions are more helpful, just because you can show more empathy during those meetings. The employee will hopefully appreciate your time in doing that, will make you feel, make them feel like you're taking it really seriously. But likewise, it is okay to do them virtually, and that might work better for you, but just consider that. Consider if the employee should have the right to be accompanied. So again, it's not a requirement to allow an employee to be accompanied at a meeting, at a protected conversation, but the ACAS guidance does say that it may be useful to allow them to be accompanied by a trade union or a trade union rep or a colleague. As a starting point, I wouldn't necessarily say you need to do that. It will depend on the employee. Again, if you've got a particularly vulnerable employee, then it probably will be beneficial to allow them to have a companion. It will probably make your conversation more useful. Likewise, if an employee asks for a companion, then you are going to want to consider that. So just have it on your radar that could be something that happens. remind the employee of confidentiality, and yes, get legal advice from the start, really, because as I said right at the beginning, you want to know whether having a protected conversation is the correct thing to do in the situation that you're in, bearing in mind what a potential claim could be if the conversation fails. Also, you want to know how to pitch your settlement offer. It's really important that you obviously make the correct initial offer to the employee, something that they can't turn down, but equally something that represents what a potential claim could be. But then really importantly, that you're actually going to make sure you're actually going to conduct the protected conversation in the correct way. So we've helped lots of clients before with having scripts, setting out what it is they're going to say in that protected conversation so that there can be no allegations of improper behaviour. And we've even had before where clients have made it known to the employee that they're following a script produced by us, because then it gives the employee far less leverage to later argue that there's been improper behaviour if they know that the employer has had advice throughout about it. And then finally, obviously, us helping with settlement agreement terms. If you've gone as far as having a protected conversation and doing all the work behind that, then you want to make sure that the settlement terms are properly recorded in an effective settlement agreement. That is everything that I wanted to say on a protected conversation. So I'll pass back to you, Lucy.
Great, thanks very much, Claire. And thanks also to Claire Hollins as well for your presentation. Hopefully you all found that really interesting. I know I did, and hopefully there's some key takeaways there for everyone. So I think we're almost bang on time. So we have had one question, but I think what we will do is we will contact you afterwards with the answer to your question. So I'm just gonna sign off now. So thank you to both Claires, like I've said, and also thank you to everyone for attending this morning. We will be sending follow-up emails, like I said earlier, and in there you will get the contact details of both the Claires, a recording of the webinar, and the slide pack as well. So yeah, look out for that. And our next HR Breakfast Club is going to be in June. So you should sign up to our mailing list so you get the invite for that one. So yeah, hopefully we will see you all next time. So yeah, thank you again for your time, everyone, and we'll hopefully see you next time. Bye.